Good evening, colleagues, students, friends. You're very welcome to the fourth in a five-event series, the 50th anniversary lecture series, celebrating our law school, 50th anniversary, obviously, of our law school here at Keele. So I'm delighted I will say a word about our distinguished speaker in a moment. But we're very proud of our law school here. I think it has a proud record and a great record of nurturing and training open-minded, critical, independent lawyers and members of other professions, indeed. And that's very much part of the ethos of Keele, and that's what we are celebrating in this series of events to mark the 50th anniversary of the school. So one thing I just want to bring to the focus of the lecture tonight is on access to justice. And obviously CLOC is a fantastic initiative. We're going to hear a little bit more about it tonight, but it's a fantastic initiative that we're very proud of, very much embedded in the law school. And we're going to have an annual lecture. So this is the first of an annual lecture to celebrate CLOC and to focus on issues around access to justice. So this is the first inaugural lecture in that series. As I mentioned, this is the fourth of the five lectures in the series to celebrate the 50th anniversary. In case you don't know about it, Michael Mansfield will be coming to give the fifth and final lecture in the series on the 3rd of May, so I hope to see a lot of you there. One thing, the topic tonight is something very close to the heart of those of us who are leading the university and faculty research strategy, actually. So I'm the Dean of the Faculty of Humanities and Social Sciences, and I arrived about a year and a half ago now. And one thing I felt that we could do is to try to develop some sense of a shared kind of priority theme for the research of the faculty, and indeed reaching into other faculties as well. So we decided we were going to launch an Institute for Social Inclusion at Keele, and that plan has been taken forward. We've had interesting consultations about it. We're very much at a point now where the Institute is not just an idea, but a reality. And that's partly made clear by the presence of Derek McGee here, who's the newly arrived, well, here about, how long are you here now, Derek? 4 weeks. So Derek will play a dual role as the Dean of Research in the Faculty of Humanities and Social Sciences, and also the Director of the Institute for Social Inclusion. So I kind of like to think that this lecture series kind of also celebrates some of the work of the Institute, which will draw together colleagues from all the schools in the faculty and many schools beyond to really produce high quality research, engage with external partners, to really have a transformative and positive effect around issues of social exclusion and how to create more inclusive social orders at all levels, national, regional, international, or whatever. So that's an exciting development that I kind of see this lecture series also contributing to. So enough about all that. Let me introduce Sir Ernest Ryder, who is our distinguished speaker tonight. And to be on this lecture series, you have to be a great friend of Keele. So it's great to welcome back such a good friend of Keele. So Sir Ernest is the Senior President of Tribunals, and he's been doing that since September 2015. Just some details about him. He was called to the bar in 1981, appointed to Queen's Counsel in 1997. He became a recorder in 2000. He was appointed a High Court judge and assigned to the Family Division in 2004. He was the judge in charge of the modernisation of family justice, and many of the recommendations were implemented by the Children and Families Act of 2014. He was appointed as a Lord Justice of Appeal in 2013, and as I say, became Senior President of Tribunals in September 2015. Sir Ernest has also been appointed as a trustee of the Nuffield Foundation since September 2014, and he's a Chancellor of another university, the University of Bolton, recent appointment, 2016. So he has been, as I say, a great friend of Keele. He's contributed to the MA in Childcare Law and Practice. He has delivered a seminar, the Social Work Law Research Seminar Series, and he has indeed been a leading contributor at the CLOC National launch. And indeed, the head of school, Alison, has told me that you and she worked together on some complex cases when she was a local authority solicitor many years ago. So another connection to celebrate. So tonight we're going to hear Sir Ernest speaking about assisting access to justice, and very much looking forward to hear it. And we'll have some time for Q&A at the end, which I'll come back for. So, here.
Well, Dean, thank you so much for a very warm welcome back to Kiel. It's always a pleasure to come to talk to you, and particularly tonight to talk about access to justice. It's been described as the most fundamental of rights that we have. Without it, our other rights, whether they be rights to property, rights under contract, public law rights or human rights, are chimerical. Access to justice is not just a right in itself, it's the key enabler for making other fundamental rights a reality. It's incumbent on all of us, whether judges, lawyers, law teachers, law students, just as it is of wider society, to do all we can to ensure that access to justice is such a reality. I'll suggest that we're called on to assist access to justice, and that's the theme of tonight. And in looking at it, I want to focus on a number of necessarily related ideas. I want to look at a principled basis for access to justice, the judiciary's responsibility for securing effective access in order to promote the effective administration of justice and the rule of law, and a civic responsibility for securing effective access. And let me start off with the principal basis. The usual starting point for explaining the importance of access to justice is to highlight how effective access is to the courts as an essential feature of a liberal democracy, one committed to the rule of law. Support for this idea would, for instance, be Lord Diplock's imprecation from the Bremer Vulcan case, where he said that, quote, every civilized system of government requires that the state should make available to all its citizens a means for the just and peaceful settlement of disputes between them as to their respective legal rights. The means provided are courts of justice to which every citizen has a constitutional right of access in the role of plaintiff, forgive the old-fashioned language, to obtain the remedy which he claims to be entitled to in consequence of an alleged breach of his legal or equitable rights by some other citizen, the defendant, unquote. Or more recent support, and as clear an explanation of the importance of access to justice as you will find anywhere, is that of Lord Reid in the Supreme Court's decision in the Unison case. A case which, I have to say, by way of interpolation, causes me grief only in this sense, that the exponential increase in claims which were always there waiting to be made when somebody could afford to make them has finally come to pass. If it wasn't for the fact that the Master of the Rolls, I and others said to government what the effect would be, they took no notice. They didn't even take notice of the Select Committee. But when the Supreme Court came to its conclusion, the effect was inevitable. But let's just go to what Lord Reid said in his judgment. He emphasised how the constitutional right of access was inherent in the rule of law, and he went further than that and went on to explain in these terms. At the heart of the concept of the rule of law is the idea that society is governed by law. Parliament exists primarily in order to make laws for society in this country. Democratic procedures exist primarily in order to ensure that the Parliament which makes those laws includes members of Parliament who are chosen by the people of this country and are accountable to them. Courts exist in order to ensure that the laws made by Parliament and the common law created by the courts themselves are applied and enforced. That role includes ensuring that the executive branch of government carries out its functions in accordance with the law. In order for the courts to perform that role, people must in principle have unimpeded access to them. Without such access, laws are liable to become a dead letter, the work done by Parliament may be rendered nugatory, and the democratic election of members of Parliament may become a meaningless charade. That is why the courts do not merely provide a public service like any other. Quite powerful stuff for a justice of the Supreme Court, or indeed for any judge. And he went on. The value to society of the right of access to the courts is not confined to cases in which the courts decide questions of general importance. People and businesses need to know, on the one hand, that they will be able to enforce their rights if they have to do so, and on the other hand, that if they fail to meet their obligations, there is likely to be a remedy against them. It is that knowledge which underpins everyday economic and social relations. That is so notwithstanding that judicial enforcement of the law is not usually necessary, and notwithstanding that the resolution of disputes by other methods is often desirable." End of quote. Lord Reid's judgment is particularly important as a caution to anyone who wrongly thinks that the courts exist as service providers. It is an antidote to the fallacious consumer view of the justice system, a view that is relatively prevalent at the moment inside and outside of government. It is also important because it highlights aspects of justice that go beyond but yet are necessary for the courts to be effective means to secure rights enforcement. In particular, it highlights how effective access is necessary for there to be a properly functioning democracy. And it does so in two ways. First, most obviously, by emphasizing how individuals need access in order to enforce their rights, and second, through a broader public access to the courts and their decisions. Now, what do I mean by that? Well, broader public access rests on an understanding of constitutional government that has been remarked upon a number of times in the United States, where the functions are of necessity slightly clearer. It is the idea articulated by James Madison that a constitution in and of itself is nothing more than a parchment barrier protecting individual liberty. He was, of course, referring to the nascent US Constitution, and we have no equivalent codification here. Our Constitution is far more of a living instrument, contained within a number of acts of Parliament, constitutional conventions and practices. But his point is, and will remain valid here, it was that unless the Constitution and the values it articulated was one that lived in the hearts and minds of our citizens, it would be of little practical utility as a defence of liberty or rights. Please just indulge me a moment in a quote. Those of you who are the Wikipedia followers will know these quotes well, but it's a nice one from Justice Learned Hand from The Spirit of Liberty in 1944, where he said this: "I often wonder whether we do not rest our hopes too much upon constitutions, upon laws, and upon courts. These are false hopes, believe me. These are false hopes. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can even do much to help it." Often described as the best American lawyer never to get to the Supreme Court. There are many ways in which a state can ensure that its constitutional values are lived values. Education, citizen engagement in wider civic society, active participation in democratic government, and through effective access to justice, through participation in our justice system. We can and do secure such participation in a number of ways. First and most obviously, we secure it through our courts and tribunals, their processes and their judgments being open to all. The constitutional right to open justice, to public justice, is of course the foundation of effective public participation. You'll find the rationale for that in the seminal case of Scott and Scott in 1913. It is through this that the courts can play their part, although that is with the government and Parliament in explaining the laws and the constitutional and legal values they embody. It is an example of the interdependence between the three branches of the state, of how they work together, even if independently, to help secure our democratic constitution. And it is through doing this that we're able to ensure that the public, not least through the media reporting what goes on in the courts accurately and fairly, are able to engage with those values and our laws. It enables them to debate and consider them. It helps maintain their vibrancy while also helping to ensure that those values can develop over time as society develops. And so it helps ensure that our constitution and laws evolve as society evolves. Second, this has a further and wider democratic role. Access to our courts helps to ensure that our courts as institutions of the state do not become estranged from society that they serve. Access is a means to ensure that our courts as social institutions remain inclusive. There are, of course, many different ways in which we achieve this. Democratic participation, not that we would often characterize it in that way, can be through the lay jury of the Crown Court and through lay justices in the magistrates' courts. There are two clear ways in which one can secure direct participation of the public. I also have lay panel members in my specialist tribunals. And scrutiny of our open courts is another less direct but equally important way. When we consider both this and access through judgments and open proceedings, we need to be astute to take appropriate steps to ensure that we secure those effectively. And I'll return to that shortly when we consider what the obligations are on the judiciary. And third, and this links to the previous 2 points we've made, we secure participation through court judgments providing the framework within which socio-economic activity takes place. As Lord Reid rightly pointed out, judgments developing the common law, articulating and enforcing statutory law, provide the underpinning of our daily lives. In the shadow of Donahue and Stevenson, as he noted, we buy drinks from cafes. In the shadow of Entick and Carrington, we rely on our property rights and the limits of state power, and so on. We rely on them without being aware of that fact. We give life to them and to the values that they give life to, whether we end up involved in a dispute that ends up in court. And for very many, if not the vast majority of us and society, we do so notwithstanding the fact that we never become involved in litigation. Importantly, and this draws me back to my previous points, it's through effective access to courts that we test those decisions and the values they articulate, and we test them over time. And it's through effective access to judgments that we can test them in public democratic debate. It's why we should never censor criticism of the judgments of the judiciary in public, albeit that one would always hope that the criticism is tempered by something. Again, the framework and access to it and the means to test it, to develop and correct it in the light of social evolution is critical. I've said recently that this aspect of what is known in the United States as observational justice should not be underestimated, particularly at a time when there is a growing tendency, otherwise to irrational populism, or at least populist propositions that are incapable of empirical validation. Access to justice then is more than access to courts in order to enable claims and rights and obligations that they engage to be adjudicated. It is the means through which we uphold and articulate the law and ensure that our laws and constitution remain living instruments of our democracy. And it's on this understanding that I want to consider the judiciary's role and civic society's role and our responsibility for ensuring that access is effective. So firstly, I'll come to the judiciary's responsibility. My starting point is that it's beyond doubt that the judiciary has a responsibility for securing effective access to justice. This arises in a number of ways, some well understood, others perhaps not so well understood. Most obviously and most well understood is the responsibility a judge has to ensure that justice is done in the courtroom. It's the responsibility to ensure that the proceedings and trials are carried out consistently with procedural principle and fairness. That is given effect through long-established common law principles such as the right to due notice of the case put against you, the right to evidentiary disclosure, to challenge the case and evidence against you, the right to equality of arms, and of course the right to open justice and judgments in its many facets. Such principles are now supplemented by more developments which are less well recognised in public and subject to perhaps more dispute in the academy, such as the now fundamentally important principle of proportionality. Although I would suggest this is not as new as some commentators believe, and we can trace that principle back into the past. We can see it, for example, in the creation of our county courts, which provided a simpler, less expensive and more effective form of justice than had hitherto been provided by the great common law and equity courts and then the High Court. We can see it in Magna Carta's requirement that the punishment must fit the crime. And it now underpins the operation of all of our civil, family and tribunals justice systems in the overriding objective in each of the sets of rules. Modern case management techniques also ensure that judges are able to ensure that effective access is secured for all claims, through ensuring, as we're required to do, for instance in civil proceedings, that when we manage claims, we do so taking account of the effect of our decisions on other claims. We do not manage claims in isolation from each other. We manage a whole system of claims and do so holistically. If you think, for example, that my judges are managing more than 100,000 benefit appeal claims at any one time, changing the way you do something will have an incredible effect. There's a long tail of any leadership decision that you make, particularly in procedural terms, wherever you have volume work, and in relation to complex work, a change of decision at Court of Appeal level, where we're dealing with the real business of how other people make decisions every day of the week, can have incredibly significant effects. Last week we handed down judgment in respect of the Parliamentary and Health Services Ombudsman, the Commissioner. She, as it was then, had removed the Bolam test from all medical negligence complaints to the Ombudsman and replaced it by the I will choose an expert, and if you don't do what the expert says is good practice, you will be found to be in breach and I will report you in public. And we condemned it as being an incoherent and unsustainable standard. She's entitled to choose her standard, but not that one. That will have the most extraordinary effect, at least until it's successfully appealed in the Supreme Court. That sort of issue underscores the responsibility we have to ensure that where individual litigants are unable to afford or do not wish to have legal representation, we take such steps as are necessary to ensure they receive a fair trial. Some people still see, and quite wrongly see, I suggest, the judicial role as extending to no more than ensuring that justice is done in and on the facts of the particular case. The judiciary as an institution, and as one of the three institutions of state, requires judges, and particularly those in what are now known as leadership roles, such as the Lord Chief Justice and the Senior President of Tribunals, to take a wider role. As Senior President, I have, by way of example, a statutory responsibility to have regard to the need to ensure that tribunals are accessible and that we develop innovative means to resolve disputes. I don't have a choice about that. That's the legal obligation that's placed upon me. And it's difficult to conceive of how this duty, or rather these duties, could be carried out if I were not to play a leadership role and simply allow things to happen in a court or tribunal hearing room. And the role is in addition to a fundamental role that the Lord Chief Justice and I have in the administration of Her Majesty's Courts and Tribunals Service. That is a constitutional partnership between the judiciary and the executive, which is encapsulated within something known as the Framework Agreement, an agreement laid before Parliament in, I think, the House of Commons library is where you'll find it. The Lord Chancellor represents the executive and does so by discharging his statutory role in providing the resources, buildings and staff to run courts and tribunals. The Lord Chief Justice and I represent the judiciary to ensure, through our leadership of the courts and tribunals judiciary, that HMCTS can support us in exercising the judicial power of the state. The idea that we could not or should not properly be engaged in developing and leading, for example, the HMCTS reform programme, a £1 billion reform programme that is the largest in the Western world, is one that stands, I would suggest, no scrutiny. It rests on the misconception that the judiciary should not be involved in leading the reform of the means through which they discharge their functions. More than that, it rests on a conception of the judiciary that was rejected in this country in 2005 when the Concordat between the Lord Chancellor and then Lord Chief Justice was signed, and the partnership model for the delivery of justice it contained was given effect through the Constitutional Reform Act 2005. So whether I would have done it or not, I'm bound by what Parliament has decided. And so that leads me directly, in the context of access to justice, to that reform programme, which is reshaping our courts and tribunals system. As a formal constitutional partnership between government and the judiciary, reform cannot but be carried out in partnership. It's not a question of the judiciary involving itself in something impermissibly. On the contrary, for one partner to absent themselves from the reform of what is a joint venture in law would be an impermissible abdication of responsibility. We cannot, but we must take a leading role. And our guiding principle in doing so is that we seek to ensure that our justice system is one that can better deliver effective access to justice at the end of the process. We're not in the business of reducing access or of producing a second-class system of justice. If that were our aim or intention, or even if we were simply playing to the government's austerity agenda, we would be complicit in a series of reforms that would undermine the rule of law, and no judge can or could properly do that. It might, of course, be objected that the HMCTS reform programme was born of austerity following the 2007 and 2008 financial crisis. It was. That as such, it is a belt-tightening exercise. It is, because we cannot afford to run the justice system in its post-Victorian form. No government of any political persuasion is prepared to sign up to that. As I've said in this lecture series on an earlier occasion, austerity has had and is having no impact on the aim which underpins the justice system or on our commitment to ensure that all of our citizens have effective access to justice. Austerity was the spur to fundamental reform, not its objective. For economists amongst you, this is a point that they would know well from Milton Friedman. He famously noted that, quote, only a crisis, actual or perceived, produces real change. When the crisis occurs, the actions that are taken depend on the ideas lying around, unquote. That crisis was for us the financial crisis. The Lord Chief Justice, the former Lord Chief Justice, described our system at that point as being in terminal decline. It forced us to consider exactly how we deliver justice. And it did so at a time of fundamental societal change. It did so because 2007 was also the year that the smartphone revolution took off. Some of you would have been just a bit too young to even remember the importance of that. With the launch of the first iPhone, the idea that just happened to be lying around was provided by the technological revolution in which we are still a part, the fourth industrial revolution. That is not to say that we ran headlong and without due consideration into embracing the use of technology as a means to reform the courts and tribunals. Detailed consideration and not a little bit of angst was given as to how and in what ways the use of digital technology could be used in this way by reform bodies, and those included Justice and the Civil Justice Council, who have some very powerful reports on reform. Consideration was given to how other jurisdictions, such as British Columbia in Canada and the Netherlands, were putting technology to innovative use through the development of online dispute resolution systems. And of course, serious consideration was given to the issue by Sir Michael, now Lord Briggs, in his Civil Courts Structure Review. The upshot of all of this work was the development of the HMCTS reform programme on principal lines that was agreed by the Lord Chancellor, the Lord Chief Justice and myself in 2016. Those reform principles that are articulated in the various vision documents that were made public were and remain what our justice system must be, that is, just, proportionate and accessible. By this we meant, and I just take one small quote from the extensive materials that were published, the procedures and remedies should be available and intelligible to non-lawyers. People with disabilities should never feel excluded because they cannot attend a physical courtroom or handle documents or traditional procedures. Likewise, people who are not comfortable with new technology must always be supported. From a practical perspective, this has meant, for instance, that we've been developing digitization of our processes through pilot schemes, such as the Civil Money Claims Online Pilot, otherwise known as the Online Court, which is in the County Court, and through various pilot schemes in the tribunals, the first of which is in Social Security and Child Support. At all times, it must, however, be remembered that these pilots and the reform programme are taking place within the context of the framework agreement. They're a partnership, one in which the judiciary has a duty to lead. Our aim here is not reform for reform's sake. Our aim is, on the contrary, specific and targeted. It's to create a better and more accessible justice system, one with better buildings, one with a better and less daunting environment within those buildings, one with new, simpler, more accessible processes, and one which facilitates better use and deployment of specialist judges. Our destination for civil, family and tribunals is for the creation of a single web-based system leading to e-filing and documentary management. The prototypes for each bit of that are in test at the moment and all exist. The aim is a system where there are no complex rules or rule books to master, but rather easy-to-use web pages which guide litigants through the litigation process, especially those who either choose to or cannot but litigate in person. Our traditional approach has tended to be the daunting. A brief look through the various procedural rule books of our various justice systems demonstrates that. They're unintelligible to all but the specialist professional. Some of them are unintelligible to the judges who read them. Greater use of the internet and well-designed courts and tribunals platforms should enable us to ensure that access truly is accessible. And it's not only court rules and procedures that can be daunting. We sometimes talk about the majesty of the law and our law courts. And I do not underestimate that our buildings are part of an institution that needs to command confidence, trust, and legitimacy, that is, respect, in order to function. And that does include what the buildings look and feel like. If you've ever, and certainly Sir Maurice and I have, sentenced somebody to a sentence of life imprisonment with 30 or more years as the minimum tariff, and the court has 100 people in it, and you have to think carefully, very carefully, the words you are going to use. It brings it home. However obvious, and I promise you it's never quite as obvious as you think it is, that the words are that you should be using, the care with which you have to articulate those positions is quite extraordinary. And yes, it does have and should have majesty. But majesty can sometimes be used to mean daunting. If you ask the sort of litigant I get before some of my tribunals, who arrives in a wheelchair with an oxygen bottle and a carer, who they may or may not know, because it may be somebody who's looking after them for the first time that day, despite the fact this is a pre-planned hearing, and they come with a sensory dog who might actually be, forgive me for saying it, the most sensible person in the room, you really do need to think about what is daunting for them. They want to put their case to the tribunal. They want to have a fair crack of the whip. And a court building and a courtroom of any kind often will be daunting to a litigant like that, particularly one who does not have a lawyer to represent them. And where this is the case, we can, unless we're careful, fail by omission to secure effective access. Daunting all too often translates into inaction, into rights not being vindicated, into abuse of public and private rights remaining unchallenged and effectively unchallengeable. Those of you who have represented domestic violence victims, just think back how difficult it was to get them to go into one of those environments and effectively have their say so that they could be protected. Access is more than simply being able to navigate court procedure and ensure your claim comes before a judge. Access requires you to take part in the proceeding effectively. If litigants are intimidated, it is unlikely they'll properly secure effective access without assistance. We already take a number of steps to ensure that they can do so, whether that is through active case management or whether it's through the very good work carried out by volunteers who work, for example, in personal support units throughout the country. We can go further. Our reform programme, through focusing on greater use of digital processes and digitally accessible hearings, aims to utilise what the vast majority of society is now familiar with, the internet. With so much of our lives now being online, whether buying through Amazon or direct from businesses, selling through eBay or similar web platforms, blogging or tweeting, many of us are at home on the net. That we are suggests to me that an internet-based process to initiate and manage and conduct proceedings will be something with which many individuals will be familiar, and to a far greater extent than the previous paper and court-building process. Greater use of the internet can thus be harnessed to increase access to justice, to genuinely equalise access. This is not to say that all process will take place online. We're not moving to an entirely online process. It may not even be a majority online process. Think for a moment about jury trials in the Crown Court. They rely on face-to-face combat. It will remain essential for many claims and procedures that they take place in that established face-to-face way. And for those claims and hearings that should take place in court buildings, the reform programme and its focus on increasing our use of technology should enable us to ensure that litigants, judges, and the courts and tribunals administration have an improved environment. Reform enables us to move away from our post-Victorian, and in some cases Victorian, court estate. We can design courts for today's environment one where bundles need not be on paper but can be on a memory stick, which is already the norm in the Supreme Court. It also enables us to make better use of space. As back offices reduce in size and are moved out of courts through less use of paper filing in those buildings, we can make that space available for litigants, lawyers and representatives, which they need when they do attend court. And it should go without saying that reducing the number of times an individual is required to attend a court building reduces the cost and inconvenience of litigation. As Jeremy Bentham might have said, we increase access to justice by reducing justice's vexations. Better access has another meaning. We're not just concerned with creating a better and more accessible system for those individuals who would litigate under the unreformed system. The reform programme's vision, and this can be seen from Lord Briggs's original plan in the Civil Court Structure Review, is an expansive one. It seeks to make our justice system accessible to those who would not otherwise bring their disputes to court. As such, it seeks to expand justice's reach to those who at present time sit outside the law's protection because they do not perceive that courts and tribunals are presently open to them, or quite simply, they can't financially afford the risk of accessing a court. The reform programme is expansive in another sense. It seeks to remake our courts and tribunals in light of modern technology so that we're looking to expand the concept of justice. Historically, justice dispensed in the courts stood in parallel to justice secured through mediation, negotiation, and other forms of consensual settlement or alternative dispute resolution. Reform in the shadow of online developments in ADR, that is in online dispute resolution, gives rise to a much broader vision of justice. And again, I don't shrink from the fact that we must maintain the incremental development of the common law through precedent. But an appropriate and compatible aim with that in civil courts and tribunals is to incorporate negotiation, mediation, and forms of preventative and preventive justice into the formal process. That is, there will be, quote, just dispute resolution, unquote, or, as it's been described, a problem-solving approach to justice. I aim to ensure that this approach is adopted across tribunals, although like in every other justice sector, there will be some elements that are only truly satisfied by the adversarial protections that will need to remain in place. But an expansive vision is one that sees accessible justice as access to a wider variety of forms of dispute resolution, and it seeks to provide the right one for the right dispute, rather than one size fits all. And just as one size does not fit all, a further practical effect of the reform programme, and the one that was clearly stated in the principles that I set out earlier, is the benefit that the development of assisted digital can bring. By this I mean to refer to something that was foreshadowed by Sir Brian Leveson when he referred to the development of what he described as digital navigators. By this he meant individuals who could help the public navigate the system. Some of this should now start to resonate with some of you. They would do so through telephone or secure live web chat platforms, or as now, face-to-face. And from this early expression of the idea we've been developing as part of the reform programme, systems to help individuals who are unable to access the internet effectively. These are quite often, of course, people who are unable to access the paper system either. But this has given us the opportunity to tackle an age-old problem. And we're testing our systems, particularly through the online court and tribunals pilots. We're learning from the feedback we're receiving how to tailor those new systems. And here we see a lesson that justice reform has learnt from developments in private online dispute resolution systems, such as those used by the major solicitors' firms across England and Wales, and, of course, through eBay. Those systems learn from their users. That's how they become risk averse. They put that learning into practice through changing the way the system operates. It learns over time. In this way, they can easily and quickly resolve problems in the system. They can understand where there are gaps in the system and plug those gaps. And so assisted digital is not just a means to improve access for those who would otherwise be excluded. It's a means by which the system itself can learn. It can assist the system by assisting the users. We have to ensure that this ability to learn from its own operation is something that we hardwire into our digitized courts and tribunals. If we do so, it will mark a quantum leap forward in terms of our ability to understand how our justice systems work, where and how they do not work, and crucially, the extent to which they deliver access to justice. Whether it's through the use of embedded data that is harvested for analysis and research, or the use of artificial intelligence to capture good practice, it's my hope that we can ensure that through the reform programme, we're able to fully realise this vision. Finally, in respect to this aspect, I want to touch on a further form of accessibility, one again which the judiciary have a duty to secure. That is the duty to bring about a more diverse judiciary, one reflective of the society we live in. It may surprise some of you to realise it's a duty. We see this duty particularly in the obligation placed on the Lord Chief Justice to act to encourage diversity in section 137A of the Constitutional Reform Act 2005. It is a duty that as Senior President I've strongly endorsed through, for instance, our emphasis on new recruitment principles for the Tribunal's judiciary that are effectively specialist blind and therefore open to more. And also that the work that we all do on the judicial mentoring scheme. There are many reasons why increasing judicial diversity is of central importance. But a more diverse judiciary means that the long web of the common law can draw upon the experience, knowledge and values of society as it is today. It helps to ensure that our law draws its strength from all of society and not a thin strand. The reason that I want to highlight tonight, though, is related to this, but goes beyond it. It goes back to the point I made earlier about constitutions drawing their strength and their value from civic engagement. Engagement occurs when people are part of something, when they can and do take part. If our courts and tribunals are to properly engage society, or rather continue to engage society, they need to be part of society, and society in its breadth and diversity must be part of our courts. Our society is open, our courts are open, and our judiciary must be open. As such, it seems to me that we need to do all we properly can. I say properly because we must, of course, act consistently with what the law permits, to encourage applications to the judiciary from all underrepresented groups. None must be left behind. We must focus on all and not just some. And in this we must tailor our approach. What works for gender diversity may not work for BAME diversity, which may not work for socio-economic diversity. It is often said that justice must not only be done, it must be seen to be done. That is as true of improving judicial diversity. We must do and be seen to do. If we do not, then it will become more difficult for the courts and tribunals to maintain public confidence. All parts of society must see they have a stake in the delivery of justice. We show that by what we do. And what we must continue to do, is ensure that the judiciary as an institution is open to all with talent, ability and experience. If, as we rightly do, we recruit the judiciary on merit, as a society we need to ensure that we nurture and develop that talent. Let me then turn to civic responsibility. This is the third issue I want to consider: civic responsibility for assisting access to justice. My starting point here again is the idea that justice is not something that is done to you. A just society is one where the delivery of justice, the commitment to do justice, should be inherent in all our institutions, in all of civic society. There are many examples of excellent work being done in this respect across the country, and it takes many shapes and forms. On the one hand, our universities, of which Keele is in the forefront, demonstrate real leadership. Law and its study is, of course, very often as practical as it is theoretical. This is particularly true of our common law system. Oliver Wendell Holmes was quite right when he emphasized the fact that the life of the law was not logic but experience. Our laws have grown cases from practical problems. Our universities now embody this truth in the work they do through their legal advice clinics and their clinic legal education programs. In this regard, the work done by the CLOC program in Keele is truly inspiring. The work you are doing for the disadvantaged in society is vitally important. It is civic engagement in the pursuit of a more accessible justice system at its best. With the ever-increasing growth in litigants in person, its work with the Litigants in Person network cannot be underestimated. It's a program that should serve as a template for others to emulate. Equally groundbreaking programs have been developed in other universities across the country. I mention just two by way of example: Kent University's Law Clinic or University College London's Access to Justice Centre. These examples show engagement by our civic institutions at their finest. You will probably have guessed from this lecture that I'm not someone in favour of the law resting on its laurels. Just as the courts and tribunals are subject to a reform programme, the aim of which is to create better access to justice, I would challenge universities to go further than they have already. There is always room to innovate. You innovate to protect the institution, to safeguard the best bits of it for those who come after you. Such a challenge was laid down approximately 15 months ago by the Master of the Rolls, Sir Terence Etherton. In a lecture to LawWorks, he suggested that universities, pro bono advice centres and organisations and law firms should collaborate to create an expanded advice scheme. His idea was that along with the legal professional regulators and the courts and government, there was scope to expand the nature of pro bono assistance to litigants in person by law students. He did not, of course, suggest that this would be unsupervised assistance. On the contrary, he suggested that there should be greater access for all of you to appropriate supervision, insurance, and even professional regulation. The benefit to all being obvious, but primarily the benefit to society. Greater assistance for those who need it most. It draws more of society within the protection of the law. The benefit to the student is the ability to use that experience as they enter the profession of their choice. He called for detailed consideration of the idea, and I'm happy to reiterate that on his behalf today. Our universities have shown they have the will and the experience to innovate here, to develop programs that are both socially responsible and of benefit to their students. In the spirit of assisting further civic engagement, could they not take the lead in helping to develop the Master of the Rolls idea? I hope so, and I hope that other parts of civic society join you in doing so. The universities are not alone. The legal profession, through the development of its own pro bono schemes, such as the Bar Litigants in Person Support Scheme, or the long-established Free Representation Unit, so long that I was able to participate in it at the Bar, and the important work done by the Law Society under its pro bono charter, they exemplify their civic engagement. Again, this shows the breadth of what is being done. And it's not just pro bono work. The Legal Education Foundation, which is another fine body that many of us are associated with, has, through its Justice First Fellowship Scheme, funded training contracts and pupilages and SILEX qualifying placements for law graduates who intend to work in the field of social welfare law. It not only provides training, it helps its fellows, as they become, gain the necessary broader skills to develop successful careers. If all these schemes and those behind them came together and collaborated, as CLOC has demonstrated, we could not only achieve a significant increase in civic engagement by our universities, legal professions, and those charities that work in this area, we would also provide a clear template for wider civic engagement, and we would lead by example. That then is my challenge for you tonight. It's the challenge I will leave you with. It's not to carry on the excellent work you're doing. That is a given. It is to lead. After all, the students who are here tonight will be the leaders of the next generation. We leave it in your capable hands to lead the development of wider civic engagement. And in leading, you will not simply be assisting access to justice, you will be playing an essential role in securing it at the heart of our living constitution. Thank you.